Thank you for joining the Oregon Bioscience Association today for our Bio, Business, and Good Beans Zoom Coffee Talk. In this time of COVID-19, info is rapidly changing, and so is the speed of business. Our Bio, Business, and Good Beans Zoom Coffee Break was created to help you keep updated with the most relevant topics of the day. These fast-track sessions are designed around topics to help businesses, bio businesses, academic institutions, and our supporting organizations. You can check out topics for next week and beyond at oregonbio.org, where you can also learn more about our upcoming classes and training certificate program. And if you or your company would like to be part of a future program and you have some content that you're interested in letting us know about, please shoot us an email at news@oregonbio.org. Today's program is being recorded, just double check that there, and will be available on our social media channels for as long as the content's relevant. So we've invited an employment law expert from Miller, Nash, Graham, and Dunn to spend some time helping us think through our workplace reopening strategies this morning. Before we get started, I want to thank our sponsors today. Their support makes our programming possible. So it's really important that we give them a shout out. We've got CAI, Nikon, Skanska, Summit Development Group, and VWR. And it's my pleasure to introduce our speaker for today's session, a roadmap for reopening the workplace in Oregon and Southwest Washington. We're joined by expert Amy Robinson, an attorney with Miller Nash. Amy represents public and private employers throughout Washington and Oregon in a broad range of workplace-related issues. She skillfully manages matters for clients regarding wage and hour, leave laws, disability and accommodation, and complaints related to discrimination, retaliation, and harassment. Amy's adept at guiding employers through policy and handbook creation, crafting employment contracts, and various other agreements. As businesses throughout the Pacific Northwest will start or continue the process of phased reopening, employers will be required to take new measures to protect their employees, their operations, and their customers. This session will provide an overview of issues involved with reopening workplaces, including divergent approaches in Oregon and Washington, guidelines and resources, best practices and common requirements, including rehiring and documentation. So before I turn it over to Amy, let me just give you a quick rundown of how this session is going to run. Amy will present, and then we'll hold our question and answer till the end. You can use the chat function or the Q&A function. Q&A is preferred, but we'll answer from either area, and then we'll end promptly at 10 a.m. If you have further questions you think about later after this session is over, feel free to send them to news@oregonbio.org, and we'll throw that information up in the chat. And now, Amy, excited to turn it over to you. Thank you.
Super, thanks so much. So, okay, we're going to talk about reopening considerations, as Julie said. So, a couple of things here. This is not going to be getting into specifics for every situation. What we've done here is really try to talk about kind of the basic rules of the road to keep in mind. So, starting point for all of this that I want to lay as basically your number one rules of the road. A lot of the questions we're getting right now are, given the flurry of activity over the past many weeks that the safe shelter in place and stay home orders have gone into effect, and as COVID has evolved, there's some confusion about kind of where are we now and where. So I want to start with the guiding principle where we were frankly before COVID, which starts with basically the primary duty of the employment relationship is to provide a safe and healthy workplace, okay? That's duty number one. It comes from the Federal Occupational Safety and Health Act, which means, and it's been fleshed out a little bit to talk about avoiding known hazards. Each of our states, Oregon and Washington, has a similar protection. And that really is our starting point, our guiding light here. It is the law. It is a requirement to keep operating. It also includes, those laws include protections around worker complaints or expressing concerns around safety. So this is where protections for making sure that complaints are heard, responded to, don't result in negative consequences come from. It also, again, we're lawyers, we get the questions, where do these liabilities, what liabilities do I need to be concerned with? These standards, the standards for how do you maintain a safe and healthy workplace, are what are used also if for some reason there is an outbreak or an injury that occurs. These are the standards that will be looked to. So these are your primary obligations and your starting point. And we're going to start layering pieces in here before we get to our checklist of, okay, now that we're through that, how do we get to reopening? So again, basic obligation is to avoid the known hazards. As initially called coronavirus, now COVID-19 evolved, that has essentially become a known potential hazard. So the guidance around that, and this was available, I'm going to hold it up because that's just what a dork I am about this stuff. I keep it handy. It was published before we are where we are today, related to, okay, what concerns, what measures do we need to be taking to identify how COVID may impact my workplace and how to keep it from doing so. So OSHA has published that specific guidance. I've tried to include the links here. My contact information is in here. So if there's something I touch on today that you're not able to access, feel free to reach out. In addition, I know given who we're talking with today, there's also special guidance for laboratory operations, again, related to COVID that are new. So be aware of that if you have lab operations. But again, most of my conversation today is really going to be focused, given that guidance is so specific and frankly has been and will continue to be even before and after COVID related to lab or healthcare operations. We're really going to be focusing on some of those missed or a little less clear locations, your average office environment. That's where there's a more confusion and a lack of clarity. So I'm going to be pretty much focused on that. So starting point is that OSHA guidance, which talks about how to identify risks, how to know risks, what to take. That is also, of course, tied in tandem with the CDC published initially interim guidance for business and employers related to COVID-19. Even though we're this far into it, it has been updated. It has never been changed from interim guidance. So that's still, it is a document that's important to be aware of now more than ever, where things like OSHA may not have felt particularly timely or relevant to your average office environment unless you were, again, in one of those specialized areas. Now that has changed. That, well, the new normal is employers in every environment need to be aware of what potential virus and obvious risks are out there that could impact the workplace. So the CDC's guidance, you'll see it referenced in the OSHA guidance, really sets up how do we identify these risks. They talk about risk categories, transmission risks, but now for our purposes today, they've supplemented that with a flow chart for planning reopening considerations. Is it safe? What do I need to be thinking about? As well as a toolkit for businesses. Again, thinking about, I hate to talk about liabilities here, but those documents are ones to be familiar with because I think they're going to be used as if something wasn't done. I think businesses will need to be prepared to explain why, because those are known potential measures that can be taken that you'll be asked about if there ever is an issue where you're being asked to explain your decision making. So those are what I call kind of baseline documents, guidance to follow here. So I put a copy, and I apologize, it's a little small to read in this format. The link was on that last slide, but that checklist I mentioned, flow chart from the CDC on reopening considerations. And you'll see it really covers 3 categories. Should you consider reopening? And it defers to the state and local, whether state and local orders allow you to. Recall, there isn't a federal order closing operations, so that really is left to state and local jurisdictions. If not, it's a hard no. Once we get into those yes categories, and that's where we're going to spend our time today, there are considerations that it recommends. So very helpful flow chart to be aware of what's out there. So let's talk about the state and local orders. So again, I mentioned I practice in, and I know we've got folks here who are on both sides of the mighty Columbia here. So on the Oregon side, we had a stay home order from Kate Brown in March and her office has updated those executive orders. And that is most of what has been issued, by the way. Lots of people are confused about what resources are out there, where do they go? There's been a flood of information. So this is trying to compile this in one place for you. Governor Brown's main landing page includes references to each of the current executive orders. Likewise, Governor Inslee on the Washington side of the river also has a landing page that reflects his executive orders. But I want to talk about how the diverging approaches that these states, although neighboring, have taken will impact reopening considerations, sometimes significantly. So let's talk about Oregon. Oregon's approach was really to close only specific businesses where there was considered to be significant contact virus transmission risks based on initial information. So that was restaurants, bars, having to go to takeout if possible. Venues were closed, salons, schools, obviously. So otherwise, businesses were required to convert to telework, but could continue to function if telework was not viable for them, so long as they followed social distancing protocols. So having to have a designated officer, having to have a social distancing or a physical distancing policy, so that if there was a concern that you weren't following it, you could show that you were abiding by these practices. And Oregon is now in the process of reopening as of mid-May, as we know, and they're doing so by really focusing their guidance on, because the reopening really is impacting in these initial stages those businesses that were closed. So the reopening guidance so far has really been focused, at least the tailored guidance has been focused on those businesses. So in phase one, for example, restaurants are allowed to open their operations with limited capacity and specific measures. Those are outlined. And so the phase and the location based on county will define much of what can be done. So in Multnomah, we're waiting for phase one. We're frankly anticipating we may get phase one approval as soon as this Friday. But otherwise, most of the guidance here is related to potential openings for these operations that have been closed, but a little bit of a gap around some of that ongoing operations. The question, of course, is when do we get to switch from virtual to otherwise? And so some of that is still in motion. Okay, but on the Washington side of the river, a very different approach to how to handle this. And I call them mirror image approaches, where Oregon basically said, unless we see you as particularly risky, you can mainly continue operating provided you follow these practices and use telework wherever possible. Washington really said, no, you can't operate unless you can telework or unless you're an essential business, and with some exceptions for essential operations for non-essential businesses. So things like somebody can go check the mail, those kinds of things. So that diverging approach is impacting how reopening is handled. So now Washington's reopening is also in phases, but again, those phases manifest very differently given those different approaches. So now the reopening, because most industry was closed down, subject to essential, and that many of you may have been in the essential, given that there were research and response to COVID and vaccine development was listed in the essential. But for those who weren't essential, those are being opened much more specifically by industry. So for example, we had phase one construction was allowed to reopen a number of weeks ago, where that's outdoor construction. It required certain protections, including measures around screening. We'll talk about some of those later, but working very differently and much more specified, required kind of delineated guidance around how to reopen, given that the closures work differently. So just want to acknowledge those. As far as big picture guidance, The equivalent of sort of, and not exactly, but where kind of big picture guidance for, are we taking appropriate safety precautions and what are they just generally besides our industry? For Oregon, you want to look to OHA, the Oregon Health Authority. They are working very closely. If you go to the OSHA site, so that the state equivalent of OSHA, they really route you to OHA and are working really closely with OHA for specific guidance. So other than some specifically tailored guidance that OSHA has done in the healthcare and agricultural industries right now, not a lot of generalized, not a lot of industry specific guidance as of yet. Washington, on the other hand, lots more industry specific guidance. Again, phase 2 is where we are in Clark County, for example. Lots of industry specific guidance related to those phases as they roll out. And that's through the Department of Labor and Industries, primarily in partnership with the Department of Health. So, okay. So again, those set the legal standards. Can you operate? That's going to be based on your local executive order and whether you're meeting the requirements for the phased reopening that are expressly set forth. Then the question becomes, can you do so safely? And that's going to be based on the guidelines of OSHA, because the federal will govern, as well as any local specifics. And so what I've done here is really take a checklist, create a checklist for us based on kind of common issues in the guidance from OSHA, from some of the industry specific guidance we're seeing. This is where we're seeing some common ground. So again, there may be more to be done based on your particular operation and location, but for right now, this is a general, okay, this is what we need to be thinking about and planning for as we look to reopening and returning to work. So the number one is making sure you've got your response plan ready. Are you anticipating potential COVID exposure in your workplace, and are you planning for it? You see those accident, injury, illness, exposure, prevention, control plans. You're going to want to have one of those for COVID-19, or you're going to want to supplement your existing plan to include COVID-19. So this is the kind of things that are involved in that. So having a clear plan and protocols related to that. So first and foremost, employers, which means your managers, all of your decision makers, your leadership, you do need to do education here to make sure folks really truly know the signs and symptoms of COVID-19 so they can spot it, they can identify potential risks, and what to have a plan for what to do if an employee develops symptoms at the workplace or discloses that they've been exposed while at work. We'll talk a little bit more about that in a minute. You'll want to make sure that your own educational materials, and these are things where we're anticipating both audits by Safety and Health Office agencies, state and federal, as well as potential questions later if there is an illness or exposure or an employee issue. So there's a reason to not only do this from a compliance standpoint, but from a risk avoidance standpoint. So educate your employees on the symptoms of COVID and how it's transmitted so they're aware of what the expectations are. For example, when we first started talking about this in early March, the symptoms were limited to essentially 3, which was a fever, coughing, shortness of breath. Now the list is a little bit longer. The CDC's guidance is really applicable there, as well as local health, of course, but they tend to be in sync there. So I usually start with the CDC, but now includes things like sudden loss of smell or taste, additional symptoms like sick to your stomach that isn't explained by something else. So check out that list. It's a little bit longer and make sure you're training accordingly. So having a plan also for isolating the potential worker if you learn that they are suddenly experiencing a symptom that may be in a way that doesn't stigmatize them, of course, but have a separate location identified, have a plan for this so that you know where you need to go and you're able to connect them to local resources for testing and medical care. You may also want to have a plan if for some reason somebody is seriously ill for transport, for example. The last one I want to mention, particularly from an employment lawyer standpoint, of course, is know what you can and can't share with others if you learn of a potential illness or exposure, and ideally have some of your template messages in place. I've gotten lots of questions over the last many weeks, of course, about, we just learned somebody, on our team has tested positive. We assume we need to get an email out to everybody in the company, and the answer is that's not typically the approach. What you'll want to do is determine where there may be potential contact, proximity. The general guidance for that is, has there been contact within 6 feet for more than 15 minutes and within the last 2 days? That's where potential contact arises. Those folks may need to be informed that they may have had potential exposure. But the EEOC's guidance, which came in to supplement, remember, an employee telling you that they're symptomatic or telling you that they're ill or may have been exposed is health information. And there are, our laws protect employee health information specifically to ensure that it doesn't factor into their decision making. So to the extent it's documented, it needs to be maintained separate from the primary personnel file, but also it should only be shared with those in a need to know. Right now, the guidance from the EEOC, which is from the laws that enforces the laws that impose those requirements, says basically, okay, we understand there's a need to inform folks about their potential risks so they can be tested, but you still need to maintain the confidentiality of the individual. So you shouldn't be sharing the name, you shouldn't be sharing the specific symptoms, that kind of thing. But you may want to say, gosh, you may have been exposed to somebody who was in this particular location during this particular period of time. And certainly employees may be able to discern who that is. That is okay. And frankly, the employee may say, it's okay if you tell them who I am, but there's no need to announce it broadly, absent or a real issue where this person may have been in contact broadly. So if you think there's a need for larger notice, I would say seek counsel on that. There are some pretty strict protections on that. You'll want to make sure you've weighed before you do something like that. Okay, continuing that list, make sure that your employees know, don't come to work if you're ill, if you've been exposed, or if you have symptoms. Seems obvious, and I think it's starting to become more of a routine expectation, but you'll need to make sure you've articulated that. Likewise, you want to make sure, and this applies frankly to whether somebody's at telework still, or whether they're able to return to work, or in a role where they've been able to stay at work. Make sure they know to disclose illness, symptoms, or potential exposure, so that you're able to. It may trigger leave protections. Likewise, it may trigger an obligation to inform others. Again, remember, if that happens, there's those confidentiality protections, and of course, to the extent there may be a workplace exposure, OSHA also governs record keeping and reporting obligations. So you'll want to consult your obligations that way. And designate, of course, a responsible individual to enforce and monitor health and enforcing these protocols. So this does not mean you are spot checking everybody for symptoms. It just means you want somebody who knows this, knows what to look for, knows to be available, and is enforcing that these expectations are in place. So let me take a little bit of a side trip here. There has been some change and understandable confusion as a result of those changes on what is the current guidance on, do we need to exclude, if somebody tells me they've been exposed or are worried they may have symptoms and are getting tested, how long are they supposed to be out? Recall the initial, probably in March when much of this was coming to light. The initial guidance was those folks need to be excluded from the workplace for 2 weeks. And so that was kind of where things started. Now there's more information about how this virus is transmitted and how it's symptomology or asymptomology in a lot of contexts. So that guidance has been updated here. I've included that here. This is from the CDC, but includes things like, now if there's testing involved, there may be the ability to return to work as soon as either 3 days since the last, if there's been a negative test, 3 days after the symptoms have subsided, so long as that's without medication, or 7 days after those symptoms first appeared, whichever of course is longer typically. That's your guidance there. Again, that's in the CDC guidance, but I know there's been questions. I also want to mention this again is layered into our general sort of workplace, non-specific, non-industry specific workplace. There are special protocols that are much different in a healthcare environment, obviously, or critical infrastructure, again, for folks in that essential functioning where they may be doing vaccine development and that kind of activity. So be aware there's special guidance for that. But this, again, in your average workplace, this is probably the standard. So, okay, back to our list. Safety precautions, screening measures. I want to check my time here. Screening measures, make sure you're thinking about, again, if there's a potential known risk, you want to think about what do you need to do to make sure you're not allowing a known risk into the workplace once you start welcoming folks back. I will tell you, again, depending on your operation and your location, temperature checks, symptom checks before allowing employees on site may be mandatory. For example, there are locations and industries that was part of that phase 1 construction I mentioned in Washington. That was mandatory. It's mandatory in other circumstances in Washington. In other contexts, we're waiting again for more guidance as this develops and as we get further into the phases. But I will tell you, it is definitely a best practice and certainly consistent with that OSHA, the general guidance that all of these agencies I've mentioned are doing. So really getting at a minimum an affirmation that somebody doesn't have a fever and isn't experiencing any of the symptoms before coming on site, and likely taking some affirmative step to confirm that. Now, I want to make a note though, this is not having necessarily taking somebody's temperature unless they're a healthcare professional. So these are typically touchless requirements or touchless non-healthcare required testing inquiries, for example, for temperature. So there's lots of technology, many of you may be contributing to it, to how to do these testings that folks are working with and being encouraged to work with. So if you're getting into suddenly thinking you need to hire a nurse on site to take temperatures, again, consult some counsel. There are other opportunities out there for you, and that adds another layer of component, because now you're essentially retaining medical information that you may not, there may be ways that you can minimize that. So using a sign-in sheet also to know who was present, be able to control that, and making sure those folks need to affirm that they have no symptoms as a condition of entry. And of course, we're seeing lots of this, promote and enforce rigorous personal hygiene practices. So make sure employees know about proper respiratory etiquette. This was probably less known 12 weeks ago than it is today. Promoting safe hand washing practices. We all know a 20-second song we can sing well with soap and water, and the means of getting every aspect of your hand. And of course, depending on your location, making sure you have access to hand washing facilities and ideally sanitizer that meets the requirements. Excuse me. Okay, physical distancing is still a component in virtually all reopening guidance. So making sure, number one, telework will continue to be strongly encouraged. So be able to dialogue about what positions, if they aren't subject to telework, be able to explain why that's the case. Be prepared to explain why, at least. I want to make a note here. I mentioned in the slide, particularly for high-risk workers, on the Washington side of the river, Governor Inslee adopted a high-risk worker proclamation that essentially said anybody who's considered high risk under the CDC's guidelines is entitled to alternative work arrangements, which means you may, even if you think you can't, you may otherwise, or at least it was difficult, you may have to do telework, or you may have to allow this person leave without interfering with unemployment or paid leave options that may be available to them. So special legal protections for high-risk workers in Washington. High risk defers to the CDC guidance, which right now includes those over 65 or with healthcare conditions. A side note on that, I've gotten a couple questions in the last week about should we exclude high risk workers? And the answer to that is no. That's its own form of discrimination. What I recommend as a means of complying with this is making sure you've clearly articulated if somebody identifies as high risk, that you may not, right? That they have that they're aware that you intend to offer alternative work to the fullest extent possible, and you invite that dialogue. That's the best way to get around it, as opposed to assuming, particularly given that these are tied to conditions or factors that are already protected by law, age, potential disabilities. I would not just presume that you need to exclude. In fact, I think you'll run into some risks there if you do. I should also mention, in the context of health conditions, and that's mental health or physical health, there also are protections under disabilities laws that may come into play beyond the high-risk worker proclamation, which I think is a step above that in Washington. But in both Oregon, Washington, and nationally under the Americans with Disabilities Act, folks who may have a health condition that is impacted by COVID and that impacts their ability to return to work or continue to work, you want to engage in an appropriate dialogue to figure out whether they may be entitled to an accommodation and to what extent. So be aware those laws are triggered in that context. I'm going to move rapidly because I've got a lot more slides. We got a lot of content today, so I apologize for drinking from a fire hose here, but wanted to get as much information to you as we could. Staggering rotating shifts to consideration, working workstations, moving meeting times, and of course, limiting non-essential travel right now. Masks and personal protective equipment requirements. Again, this is really in your non-specified, non-healthcare environment we're talking about here, which is whether it's mandatory or optional right now really truly depends on your location significantly. I will mention, regardless of where you are, if masks are required, and I'm going to talk about that more in a minute, there may be exceptions that you also need to consider. So let's talk about current guidance about just the general concept of cloth masks that we're seeing for sale just about everywhere right now in your average office environment. Are they optional or are they mandatory? Okay, so OSHA, new guidance just on Monday that basically says, unless you're working a job where following our existing respiratory guidance, which includes additional updates for COVID-19, so typically healthcare or related fields. There are others, of course, too, but unless you qualify, unless you're triggering something more than a cloth mask, OSHA is not going to consider a cloth mask PPE, which means it's not required to be provided by employers, and they're not going to be citing for, they're basically treating it as optional, but encouraged for their purposes. In Oregon, similarly, a little bit murky. I frankly expect more guidance on this, but unless you're in those specific industries, obviously, again, healthcare or some of the agriculture, well, there's been specific guidance on it, but where you're in those specific industry sectors like restaurants, salons, again, where there's been specific reopening criteria, there's a bit of a kind of an ambiguity that makes it look like it's certainly strongly encouraged, and when you're out in public, yes, but there's not a lot of guidance around it other than that. But in Washington, it's mandatory right now, and which means employers have to be prepared to provide them. Of course, if an employee wants to wear their own, that's fine, but that was a bit of a surprise, I think, for folks, although we're starting to get used to the changing world. Okay, so back to our reopening checklist, sanitation considerations. Again, this is focused on kind of an office type environment where some of these things may not be quite so prescribed in historically. So housekeeping schedules during the day, I'm talking, obviously this is in addition to pre or post work janitorial, which may also need to be stepped up, but making sure you've got a protocol for, if for example, you are able to use your conference rooms, what's the process for cleaning it, making sure you're allowing delays around scheduling so that cleaning can occur, those kinds of activities. Obviously, making disinfectant wipes available. This is, again, more of a checklist for you as you're thinking about what do we need to be thinking about? Is there anything we're missing? Disinfecting commonly touched surfaces, as well as equipment and tools that may be shared between or left behind. Obviously, also shared work vehicles. A couple of additional notes around safety protocols that I want to, watch my time here, make you aware of is the CDC does offer cleaning guidelines, also does refer to EPA guidance on what cleaning substances are sufficient for purposes of COVID-19. Also, don't forget to keep SDS sheets for your cleaning products, as well as making a plan to have sufficient supplies in hand. That has and will continue to be potentially an issue for, are we able to reopen? That's an important consideration, is can we keep those supplies in place? Otherwise, you're reversing course. So you want to be thinking ahead for that. Additional physical distancing methods of helping to plan and prepare for physical distancing. Occupancy limits on conference rooms. There's template signs right now that OHA, Oregon Health Authority, offers for this, so that you can help to regulate that. Marking the floor, you see that in our grocery stores, for example. It's maybe something you need to enact. Staggering use, as I mentioned, of conference rooms. I want to mention, because there is, we're hitting quarantine fatigue. I mean, I'm not coining that term myself. Folks, it is not easy to be doing work virtually. So we're hitting a tension point here. So folks are getting really anxious to return to work. I just wanted to mention, for those of you in Oregon, we are still right now under guidance that says meetings are required to be virtually as much as is possible, not as convenient. So be thoughtful and make sure you have a criteria so that you can demonstrate why, if you feel that something was truly necessary or not possible to be done virtually, how you came to that decision. Thinking about vendor visitor protocols, I'm going to start moving a little quickly because I want to get through all these slides today. Thinking about those. Facilities modifications, thinking about adding screens, adjustments you can make to consider making things touchless, as well as impacts you can have on ventilation and air circulation, given that COVID, the data now talks about the airborne transmission and the particulates issues there. Okay, I want to talk before we're done here, and I want to be thoughtful about time. Policies, practices, training, and posters. You want to be careful on making sure that that your protocols are reflective and don't conflict with your existing policies. As you know, there have been new employee leaves that have been adopted. I've referred to the FFCRA leaves. Lots of information about this on our website, but that's the paid leaves that were adopted as effective as of April 1. Those policies are in effect till December. Make sure that your existing policies incorporate with those, or you've adopted those temporary policies, and make sure you've got your posters up. Be aware that those leave protections still apply. I've mentioned those accommodations for folks who may have health conditions that are impacted. And there may be additional opportunities for leave. I've mentioned the policies, procedures. The other ones to think about are your attendance, your telecommuting, and your information technology as you work to a virtual workplace. Consider the impacts and making sure you're updating those. Likewise, if you're adjusting shifts or scheduling, you want to think about how that's going to impact your break policies. Also consider any stigma issues that may be coming up related as a result of this, and continuing to enforce your non-discrimination policies. Lastly, this is an opportunity, if you've got folks who've been out, you've maybe had to furlough, or you've had to even lay off and you want to recall folks, you want to make sure you're checking into your new hire paperwork, your employee covenants agreements. This is a time to update those if you're needing to, or making sure they're in order. And if somebody was absent and is returning, there are rules in both Oregon and Washington where they may have forfeited their sick leave, but if they return within a certain amount of time, in Oregon it's 180 days, in Washington it's 300, you'll want to make sure that you've recredited the prior accrual of paid sick leave. And oops, I'm going backwards there. So, okay, I did get through most of it with time for questions. I apologize for that here, but we've got just a few minutes for questions, so I wanted to take some time to do that. As I see the screen, I apologize.
Yeah, no, thank you so much, Amy. That was so much great content. So we've got a couple questions in the system here, and I think if you're okay with it, we'll just keep going for a while on questions, and if folks have to drop off, you'll be able to watch this when we post it on our social media. So I had one quick one. You talked about temperature taking potentially being a strategy, and maybe even mandatory. I've heard companies talking about having coworkers take each other's temperature, and I wonder if there's a HIPAA or privacy issue with that?
Yeah, I will tell you, if I would have a concern around that, simply because if you're having, first of all, if you're retaining this data, it's company data. I would not put coworkers in a situation where they're verifying for each other. I would actually make sure that to the extent that somebody is taking anybody else's temperatures, we can show they're qualified to do it. There's a clear protocol for what they do with that information. Again, if we're recording temperature data, even that is a potential health record that needs to be contemplated from record keeping requirements and confidentiality concerns. But I mean, I'll tell you, initial reaction is that is not a good idea, and I think there are better ways to do it that will keep a company in better stead with those issues.
Great. So I've got one here, and Doug, I may just unmute you. I'm going to allow you to talk, and I'm going to go through your question. It says, some employees can be very black and white. When coming into work is optional at their discretion and comfort, they come back with, so their comment is, you are requiring me to work. And what's the liability around that? What's the best way to handle it? And Doug, you're off mute if you want to expand on that, or if Amy, you have any questions for Doug.
Yeah. This is the issue du jour right now, is in navigating this. How do you both let folks know about what, and that's one of the slides I kind of breezed through quickly, is make sure you're educating folks, even those that are in virtual work particularly, what steps you're taking to make sure the return to work and the coming into the office is safe. If somebody says you're forcing me to come to work and they have a particular safety concern around it, remember I mentioned very beginning, there are protections under state and federal law where an employee may have reasonable, legitimate fears about safety. Of course, those are fun terms right now because, there's opportunity for debate on what's reasonable and what's legitimate. I understand that, but if there is a potential reasonable, potential legitimate fear for safety, they may be, first of all, protected, which means you don't want to necessarily terminate them. So I think it's important to dialogue around what is the particular nature of the concern so that you can assess the reasonableness, the legitimacy of it, and figure out if you may get to a crossroads. We're seeing lots of that right now, which is we are confident that we have taken all steps that we can, that it is as safe as it can be, and they may say, I'm still not comfortable coming back. You'll want to then make sure you've explored, is there any potential leave entitlement before you assess otherwise? Does this trigger, is there something where they maybe have a health condition and they're triggering one of the new FFCRA leaves, like emergency paid sick leave? Or are they entitled to FMLA, for example, because something has triggered a serious health condition? Absent serious health condition or caring for someone with a serious health condition, FMLA and OFLA typically aren't triggered, but you want to make sure you've explored that. Leave could be entitled, could also be triggered. I mentioned that in the high worker context. If there's a potential disability, it may even be a mental health disability. There's lots of data and scenarios playing out here where there's a mental health issue potentially with anxiety or other conditions where fear of COVID is really immobilizing the person, and that may trigger an entitlement to leave, which means you've got to give them that time off. It would be unpaid. You've got to give them that time off without terminating them if you're able to do that. But that requires a careful dialogue. And if you get to that stage, that's where we spend much of our time advising clients. I would say seek guidance from your counsel on that one before you terminate. If somebody's raising a safety concern and saying, I don't feel safe, you've had the dialogue around, here's all that what we're doing, help us understand what the concern is. If we're in Oregon right now, I think we're still in a place where at least in Multnomah County, where virtual work is really supposed to be the default. So you want to be careful right now about saying you got to be in the office, because you got to better be ready to back up that it was truly a critical need that couldn't be performed virtually. But once those standards open up, I think you want to be thoughtful about whether there may be a leave protection, and then make sure you're comfortable and advised about, do you have any risk based on potential retaliation protections if somebody could have legitimate, reasonable safety concerns. So a little bit of a winding road, but that's kind of the thought process when you get into those issues.
Yeah, thank you.
That help?
I think so. A lot of great, again, content in there. So I just want to clear something up. Since Thursday morning is trash pickup at my house, that's not an acceptable reason to not hold this virtually. I have to still do that, right? Sorry. We do have one more legitimate question in the Q&A here.
I was paying rapt attention to that one before I figured out you were kidding.
So sorry. Okay, so let's get serious. I have one employee in a remote lab on a college campus. Almost all items in checklist don't seem something we can realistically implement. Do you have any recommendations for how to handle this situation, compliance with standards for the college campus research department? Yeah. And I'll throw something kind of related, I think, at the end of that. So we have a lot of different sizes of companies in our membership and on this webinar with us today, from a headcount of 1 to up over 500, right? And so there's a mixture. Right. Some of them are also in office buildings where they have control over the space that they're in, but maybe not, what's the due diligence around making sure that your landlord is complying, right? So that's right. Question there.
Yeah, and actually those go really well together, because the truth is, you do have the landlord or the property owner has an obligation under these. Again, there are negligence components. We're not in the employment world anymore. We're in different laws that can be triggered for again, the kind of the known hazard concept, but now we're out in society or in the building, not necessarily in the workplace. Okay, but the building is part of the workplace, which gives to the extent the employer is the tenant, they need to be assured that in the path of coming into the workplace, and for example, there are businesses downtown right now, I happen to know well, which are struggling with how for the operations we're maintaining, can we ensure the safety of our folks coming in from the parking garages with the protests going on. Those are important factors. So let me back up for a minute and get to the question that is basically, we've got somebody in a lab environment for us, but on a college campus. The reality in those situations, just as it is in a downtown office building, is there are probably going to be 2 layers of potential protections, potential restrictions, potential compliance tasks. And so in the college environment, for example, there are colleges right now are being flooded. I know, because we do a lot of work with schools and universities around what there is a unique caretaking expectation on a college campus that isn't exactly the same, frankly. In fact, it's quite different from your average, skyscraper environment. So there are special guidelines being imposed that you will have to comply with as a product of having somebody on site there, that may be more restrictive than what you would do if it was your own. I mean, if you just had your own lab and you were in control of the environment itself. So those university restrictions will apply. You will likely have to abide by them. Conversely, if for some reason, right now from what I'm seeing, it would be hard for me to imagine, but it could happen. If your standard of care, meaning you wearing your employer hat for your employee who is on this remote location, you have to apply your standard of care to this person. Okay, and so if you don't feel that whatever measure is occurring at the university, even if they feel the measures they're taking are appropriate, you need to apply your own standard of care to that. That may require advocacy with the university to say, boy, as I read the guidance related to labs in particular, not general this other component, I think we need to do X. So it may require that, or it may be, you may feel that the answer is, I can't put this person there and feel that they're safe. I expect what the question may be more about the opposite of that, which is, I don't think we should have to do that. I think they're maybe going overkill. What are my rights and obligations in that regard? So I think the challenge is, to the extent that the operation is on the campus, those community standards that the university is able to set as part of their duty of care are going to apply. Yours may be in addition to that, and you certainly have the ability, typically in some of this, frankly, maybe individualized guidance based on the agreement and how it's manifesting there. But two sets of standards may apply, and they may work in tandem, or yours may be higher. And if that's different, you'll have to decide kind of how to navigate that.
Thanks, Amy. I don't see anything else in the Q&A, but I had one more question. You mentioned FMLA and some duties around leave. And if you covered this, I apologize. But in terms of size of company, headcount, are there different rules for smaller companies, for instance, than for larger around that?
Yeah, and let me apologize, because we could do an entire hour on the leave issue.
Yeah, I'm sure.
So first, not just a plug, we have been writing and publishing extensively on this because there have been so many changes to keep up with. So there's a reason I have our library reference there. We have a lot of information that the Families First Coronavirus Response Act imposed 2 potential leaves. So let me try to unpack that in as quick of a soundbite as I can for you. One of the big changes from pre-COVID to now is that the FFCRA imposed 2 new types of employer-paid leave, and it applies to employers with 500 or less employees. It was strange at the time. It just is what it is, meaning it was a little funky because we're imposing this obligation. And typically when we see that, we usually see exemptions for small business. And this was the opposite. It was a congressional act where big business, those who were over 500 were excluded. Maybe there was the assumption that these leaves were already available. But at any rate, those leaves are new to employers, and they apply if you're less than 500, okay? And that will involve 2 potential weeks, up to 80 hours, for what I call EPSL, emergency paid sick leave, which there are 6 reasons that could trigger that for the employee. And that's their own. They've been advised to quarantine by their doctor. They've been advised to quarantine by a health official. They're seeking treatment. Essentially, they're seeking a diagnosis, and they need to care for somebody who's in one of those other situations, or their child's school or daycare has been closed. The 6th reason was a bit of a kind of a catch-all that said, or something else, in case there was a tandem virus that evolved. I think was that. So that, if any of those situations arise, there are potential paid leave requirements. There are different prescribed pays for those. Like I said, I could spend a lot of time on this, but two weeks of that, and that's for every employer under 500. Up to 12 weeks for EFMLA, which is also if the child's school or daycare is closed and the employee is needed to care for them, with some caveats around that. 12 weeks, the first 2 weeks are unpaid, with the assumption then that EPSL will be elected during that time. So it's paid during that, and that would apply from 1 to 500 employees. There is a small business exception though for that leave, for 1 to 50 employees, that we have a resource and even a video about how do you trigger that and how do you apply it. So those 2 leaves are new since COVID and could apply and would apply to small business potentially, unless one of the exception applies. Otherwise, FMLA doesn't apply until you have 50 or more employees. Washington's equivalent of that is also 50 or more. Oregon's version of that is 25 or more. So there's that it's a little bit smaller there. Those can apply. For the most part, FMLA, Washington's equivalent and Oregon's equivalent, generally are triggered for serious health conditions, which is like hospitalizations, surgery recoveries, those kinds of things. So your average COVID scenario, unless they're complicated and they're in the small percentage that is, seriously impacted by it, typically that doesn't trigger. With the exception that Oregon's made a quick rule change that's only in effect till September that says we're going to allow OFLA. So for those employers with 25 or more in Oregon, we're going to allow OFLA to be used. So up to 12 unpaid weeks. The other ones I've been talking about are paid for if they can't work because their child's school or daycare is closed. So those are the ones that are really COVID related leaves that could apply, besides the potential leaves because I'm not able to work because I'm either high risk or or because something around COVID impacts an existing health condition. Those are really the primary ones.
Great. Thank you again. This has been so informative, and I know we could just go on for hours and hours, and we've got 2/3 of our audience still with us this morning. So kind of a testament to how relevant this really is.
Oh, good. Well, thanks for sticking around. And I, like I said, it's drinking from a fire hose to try to get the key bits that we put in there there's still a lot there. So I apologize. It was a bit of a flood, but feel free to reach out. As I said, I'm happy to answer follow-up questions. Lots of resources that we just couldn't, in the interest of time, get into today on the website. Or like I said, if any issues chasing anything down, feel free to reach out. I'm happy to send you the links. So glad to be asked.
Yep. And we'll put it, Amy's agreed to make her slide deck available, so we'll send that out via email to everybody who's registered and attended this morning. I'd like to take this final opportunity to thank Amy and Miller Nash, Graham, and Dunn for providing this great content for us. Want to let you know that this is sort of part one of a 2-part series we're doing with Miller Nash. So 2 weeks from now, on June 24th, we have a session on sort of the rules or best practices around teleworking and digital, protecting your digital privacy. And I'm not doing a very good job of promoting this session, but it's also going to be a great one and very timely and relevant. So you can find that at oregonbio.org/events. I also like to thank our sponsors again, CAI, Nikon, Skanska, Summit Development Group, and VWR. You can learn more about Miller Nash at millernash.com, and we thank you all for joining us today. This ends our session. Goodbye.
Thanks so much.